Generally, if a person revokes a will, then that will is ineffective upon the person's death. And if the person hasn't executed another valid will, then the person's estate will pass by intestate succession, meaning it will be distributed to the person's heirs as determined by state intestacy statutes. In Oliva Foster versus Oliva, we explore the doctrine of dependent relative revocation as a means of reviving a revoked will to avoid intestacy. When Patrick Oliva married Judith Oliva, he had two children, Debra Oliva Foster and Patrick Oliva Jr., whom we'll refer to as Junior. Judith also had a daughter, Cheryl. In 1995, Patrick executed a will that named Judith as his primary beneficiary and named Debra, Cheryl, and Junior's children, but not Junior himself, as contingent beneficiaries to take if Judith predeceased Patrick. In 2002, Patrick executed a new will, again naming Judith as his primary beneficiary, but this time listing Debra, Cheryl, and Junior as the contingent beneficiaries. When he returned home from executing the will, Patrick asked Judith to tear up the earlier will, and she did so. When Patrick died, the 2002 will was admitted to probate, but Debra and Junior contested its validity and argued that because the will was invalid, Patrick's estate should pass by intestate succession. Indiana's intestacy statutes would have divided Patrick's estate between Judith, Debra, and Junior. In response, Judith countered that if the 2002 will was invalid, then the doctrine of dependent relative revocation would revive the 1995 will, under which the entirety of Patrick's estate would still pass to her. The trial court granted summary judgment in Judith's favor, and Debra and Junior appealed to the Indiana Court of Appeals.